Welcome to Healthcare Fraud and Provider Billing Litigation in the Era of COVID-19. We're excited about today's program. We have a lot to cover and only 1 hour to cover it. So necessarily, this will be a very high-level discussion. And many of these topics we could talk about for hours, if not days. Should also emphasize that today's discussion is going to be focused principally from a payer side perspective, private payers, meaning health plans and insurers. We'll also be discussing, the interests of public payers, essentially the state and federal government. My understanding is for the attendees, there's a question and answer box, should be on the right side of your screen. We will endeavor to address your questions. If we're not able to do so during the presentation, we will collect the questions afterwards and get back to you with answers. Additionally, there will be there is a CLE for today's program, and later on in the presentation, we will provide you with the CLE code. Next slide, please. Okay, here's the legal disclaimer. This presentation has been prepared for information purposes only. It's not intended as legal advice. If you need legal advice, please contact a lawyer, and certainly we'd be happy to assist you, so contact us. There's the disclaimer. Next slide, please. Okay, today's panel. Hi, I'm John Braunstein. I'm a partner in Seyfarth San Francisco office in the litigation department. I've got a broad-based commercial and business litigation background with an emphasis in healthcare, insurance, and employee benefits. I have the privilege of being joined today by Rebecca Bryant. She's a well-regarded associate in our Chicago office in the Labor and Employment Department. She has significant experience in ERISA and employee benefits counseling and litigation. Also joined today by my San Francisco colleague, Brad Perkins. Brad's a partner in our Labor and Employment Department. Likewise, Brad has substantial expertise in ERISA and employee benefits counseling and litigation, and we've been working together for the last decade in various capacities on healthcare fraud and provider billing litigation matters. Brad?
Yes, thanks, John. Thanks for that introduction. And seeing that picture makes me want to give another disclaimer that it was taken pre-COVID, and it does not reflect the fact that I have not had a haircut for 6 months. But we're excited all to be here today and excited to have you with us. We'll give kind of a broad overview before turning it over to Rebecca here, who's going to give us an introduction into healthcare fraud and the problem that it poses for the healthcare, insurance, and payer industry. We're also going to talk about the impact of COVID-19 on healthcare fraud because, as John will describe it, it presents particular issues and problems. And then Rebecca and I will discuss the types of healthcare provider billing fraud and select key issues facing those litigations. And John and I will discuss the collection and fraud litigation between providers and payers. And then I'm going to finish it off with some best practices that plans and payers and plan sponsors can take with respect to the structure and administration of their plan in order to avoid fraud and also avoid litigation with providers. So with that, I'm going to turn it over to Rebecca.
Thanks, Brad, and thank you all for being here today with us for this webinar. I'd like to add that we truly welcome any of your feedback or questions on these interesting topics after our conclusion. As Brad indicated, we're going to start out by giving some background and context to this problem that we call healthcare fraud. In the health space, the reason, or one of the primary reasons we say healthcare fraud is a massive problem is because of the tremendous financial and social burden it presents. Of the $3 trillion spent annually on healthcare expenditures, it's estimated that tens to hundreds of billions of dollars are spent as a result of fraudulent healthcare expenses. And you might be wondering, how do these dollars get so high annually? How are there that many fraudsters among the good people doing amazing work in this health space? Well, there are multiple different types of fraud schemes that can occur, and we're going to be discussing specifically examples later. But for now, just consider how one bad actor can greatly impact those figures. We see time and time again examples of just one provider charging over $600 million over the course of multiple years as part of fraudulent services schemes. And so that's with that, it's not hard to see how these dollars can really rack up. So preventing fraud to reduce unnecessary spending and recovering wrongful payments made by fraudulent providers and protecting members and consumers is a really high priority for the various payers. By that we mean health plans, insurers, et cetera. The federal and state governments have partnerships with various agencies to identify and pursue investigations against these fraud offenders. Insurers rely on SIUs and vendors and artificial intelligence powered by fraud detection solutions. However, self-funded plans are often underprotected with less ability to identify fraud. So what should payers or investigators be looking for? Let's define what constitutes healthcare fraud. Here on this slide is a broad definition to assist you in your preliminary issue spotting, and for many of you on the call, it's just review. Healthcare fraud is the intentional deception or misrepresentation of healthcare transactions by a provider, employer group, or member for the sake of receiving unauthorized benefit or financial gain. Healthcare fraud is committed when a dishonest provider or consumer intentionally submits or causes someone else to submit false or misleading information for use in determining the amount of healthcare benefits payable by an insurer, health plan, or other payer. So we will see specific examples of this later, which all fit into this general definition that really boils down to intentional misrepresentation of some kind for financial gain. So why focus on healthcare fraud? We're focused on healthcare fraud for reasons that probably seem obvious. First and foremost, to reduce the cost of healthcare without interrupting or cutting benefits, which means lower costs to all, including the government, private payers, and ultimately participants, employees, beneficiaries, et cetera. And second, ERISA fiduciaries have special duties to protect plan assets. So liability can arise merely from a failure to have measures of detection and deterrence of fraud in place. And thirdly, here we have listed several types of collateral damage, such as corruption of medical histories, HIPAA violations, data privacy breaches, and notably, fraud can cause physical harm to patients, which is a different type of damage, but it's not hard to imagine how patients can be physically harmed directly if providers are manipulating records or giving treatments that are inappropriate.
Thanks, Rebecca. Let's talk about the impact of COVID-19 on healthcare fraud. Next slide, please. So, unfortunately, the COVID-19 era is a fertile breeding ground for fraud. Let's talk about why for a few minutes. It's really a math algebra equation. Money plus opportunity plus scale equals fraud. So per the FBI, let's talk about money first. Per the FBI, U.S. domestic fraud totals $80 billion per year in healthcare. Ad waste and abuse, arguably hundreds of billions of dollars more per year. In response to COVID-19, there are many, many new government programs and economic stimulus programs that have pumped trillions of dollars into widespread circulation, the effect of which is to create an unprecedented cash grab. Can we forward one slide, please, for a moment? So on this slide, I've just listed, a couple of the, four of the major, pieces of legislation that's been passed by the U.S. Government, as part of its COVID-19 monetary response. Certainly, you may have heard of the Coronavirus Preparedness and Response Act, also the Families First Coronavirus Response Act, the Coronavirus Aid, Relief, and Economic Security Act, often referred to as the CARES Act, as well as the Paycheck Protection Program, PPP, and the Healthcare Enforcement Act. These are just four of the big ones. Things are obviously moving fast. These programs are being supplemented. There's additional monies being pumped into the system. But the point of this slide is really just to show you the vast amounts of effort and dollars that are being pumped into the system. Can we go back a slide, please? Thank you. Okay, so, with the government, with COVID-19 and the government's response, everything is uncertain, everything's moving fast. One of the challenges of these programs is in their, intention to get money out into the system quickly. One of the consequences is that there's a lack of sufficient pre-screening and quality controls. Again, everything's uncertain, moving fast, and this can lead to confusion, mistakes, and sometimes fraud. In terms of these government programs, I would make 2 points, that we'll address further later. One of which is, you have to be eligible for the monies that you received, and that often requires that you make express or implied certifications, to get these funds, and that certainly can lead to liability in fraud areas that we'll talk about today. Another thing about the government response and stimulus, there are strings. The stimulus often mandates coverage for COVID-19 testing and treatments, and we'll talk about that a little later too as well, often with limited management control and utilization review. So, the money that's put into the system, will have consequences that we'll talk about during this presentation. All right, having talked about the money and the opportunity, we should talk about the last variable on opportunity is really the most important one. It's that people are stressed, scared, and vulnerable. If you are in danger of losing your job or your income, or you've lost your job, or you're home taking care of your kids that are out, that are homeschooling your kids that aren't in school, or if you're caring for an aging spouse or a parent, or you're just scared of catching COVID-19, or any number of variables. Mental health is a real issue now, and people are scared, stressed, and vulnerable. And when you're scared, stressed, and vulnerable, that's when mistakes are made. That's when consumers and businesses may be more susceptible to fraud, and in some instances, may resort to engaging in acts of fraud. So for all of these reasons, COVID-19 really is a breeding ground for fraud. And in terms of scale, this isn't limited to one city, one town, even one country. It's truly a global pandemic. It's impacting everyone, and it creates for large opportunities. 2 slides forward, please. Okay, having looked at the math equation, let's look for a moment at some of the permutations for healthcare fraud and healthcare insurance fraud. We're going to talk today a lot about these top 2. Certainly, there's opportunities for healthcare provider billing fraud. We will talk about, performance, diagnosis, necessity, kickbacks, self-referrals, bundling, coding. Those are issues, again, we'll talk about further. Price gouging and counterfeit goods is another one. Certainly in the healthcare space, there's been, issues in terms of price gouging and counterfeit for medical supplies and personal protective equipment, among other areas. But just to list briefly here some of the other, permutations and opportunities for healthcare fraud and health insurance fraud. Various mail, phone, text, door-to-door solicitations. I think maybe you've seen in the news, various fake testing sites where, people pose as healthcare workers where they're just trolling for cash and your personal health information, PHI. If they obtain your driver's license, your healthcare information, your social security number, certainly that can lead to a lot of fraud. Scam selling, fake treatments, cures, disinfectants, cyber attacks, malware, ransomware. When you're scared and stressed and you click on a link that you shouldn't, the next thing you know, you or your business is the victim of a cyber attack. Scams regarding economic stimulus payments, that can take multiple forms. And again, we also talked about previously how if you get money from the government, you need to certify that you are eligible. And if you're not, that too is fraud. False claims for unemployment benefits, employment fraud, pretending to have COVID to avoid having to go to work, scams selling fake coronavirus insurance, any number of insurance marketing scams. Certainly there are a number of telehealth issues and considerations that are raised. Telehealth used to be on the fringes. Certainly it is going to become a more mainstream piece of the healthcare puzzle. And certainly how do we account for issues in telehealth? There are also auto insurance, personal injury scams, staged accidents, things along those lines. This is certainly a non-exhaustive list, but just so that you're all thinking about broadly, COVID-19 and the opportunities for fraud. Rebecca?
Thanks, John. Now that we've learned a little bit about the COVID environment, let's drill down on some specific examples of healthcare billing fraud that we see commonly and we expect to be as part of a rising trend. So first, let's look at billing for services that were not rendered, which means either by using the genuine patient information or through identity theft for the purposes of obtaining payment, misrepresenting non-covered treatments as medically necessary, covered treatments for as medically necessary covered treatments for the purposes of obtaining payment. This is widely seen in the cosmetic surgery space. We often see it, for example, with procedures such as nose jobs being billed to patients' insurers as deviated septums, or breast augmentations billed as mastectomies. On the flip side of that, there are many billing disputes in general, having perhaps nothing to do with fraud, but just where providers are questioned as not doing things medically appropriate or based on protocols. We see a lot of authentic disagreements here, aside from fraud. But in the COVID context, we think this area is going to be more pronounced as rules and regulations are seemingly changing every day as new information emerges regarding COVID, and with coding and billing policies shifting to account for this information. We expect disputes over billing in general to be trending up. We've also seen a large increase in utilization of mental health and telehealth visits in many of the plans that we advise, which could indicate a rise in potentially medically not necessary claims, which this is an area of high risk involving fraudulent or abusive billing. We also see upcoding, which refers to falsely billing for higher priced treatment than was actually provided. This is also often accompanied by an inflation of what the patient's actual diagnosis code is to a more serious condition, consistent with the false code. Unbundling is where services that are coded as pre-bundled one service, and they're unbundled to account for each step of a procedure as if it were a separate procedure, though it's only one. We see kickbacks to patients, offering valuable gifts to them to influence their choice of provider, which raises obvious quality and cost concerns. Providers then have an economic incentive to offset the additional costs attributable to these types of gifts by providing unnecessary services or by submitting cheaper or frankly lower quality service. And we are going to take a deeper dive into corporate fraud and excessive charging and price gouging, particularly in this COVID environment. And John's going to take that over.
Thanks, Rebecca. So we're going to highlight a couple of key issues, one of which is price gouging, which is rife in the COVID-19 era. Price gouging occurs when, during abnormal market conditions, a seller increases the price of goods, service, or commodities to a level much higher than is considered reasonable or fair. Essentially, it's unconscionable or exorbitant pricing after a demand spike or supply disruption during a public emergency. Now, in other eras, not COVID, right, common examples often involve excessive price increases for basic necessities after a natural disaster, say a hurricane. In many jurisdictions like California, price gouging during a declared state of public emergency is a crime. Regardless of whether criminal or not, price gouging is generally discouraged and may be considered exploitive or unethical. Price gouging is usually short-term, localized, and restricted to essentials such as food, clothing, shelter, medicine, and equipment needed to preserve life and property. Next slide, please. Let's talk about COVID-19 price gouging. So the COVID-19 pandemic presents unique issues from a traditional natural disaster. First and foremost is the expansive geographic scope. As mentioned, this is a worldwide phenomenon on a worldwide scale. The next variation is that, with COVID, this is a long period of sustained period of emergency with no known end date in sight. Usually the period of emergency is 30 days, 60 days, 45 days, and obviously we're well into our fifth month now. We've been in a state of emergency in most jurisdictions since mid-March. Another unique thing we're seeing with COVID is the run on not only expected items, but also unexpected traditional and non-traditional necessities. In the healthcare, space, certainly, obviously, personal protective equipment, disinfectants, hand sanitizers, surgical masks, various medical supplies. But interestingly, you're also seeing a run on other items. There was a run on toilet paper, run on hair dye, exercise equipment, and there's unique questions on whether those are the types of goods and services that really should be subject to the price gouging statutes. So ultimately, COVID-19 presents tremendous, unprecedented opportunities for price gouging. A close friend of price gouging, by the way, is price cutting. It's COVID-19. You don't think of that as often, but COVID-19 also presents opportunities for businesses that can afford to lower prices or to essentially to undercut their competitors and drive them out of the marketplace. And there are similar restrictions in many jurisdictions on price cutting, just as there are on price gouging. But certainly, in the COVID-19 environment, healthcare services and supplies are particularly susceptible to fraud and aggressive billing practices. Just to give you, 3 examples, certainly, counterfeit goods. There's certainly and intellectual property infringement. I can think of, off the top, there's one maker of, surgical masks that have been counterfeited, and that company has had to spend substantial resources and litigation dollars protecting the integrity of its goods in courts throughout the country. Another thing on price gouging, right? We talked about this a little bit before, is that some of the new laws that are in place and regulations essentially mandate coverage for COVID-19 testing and treatment, and impose limitations on management control and limitations on utilization review. So how much is this going to cost, and how many times do you have to cover it? One bullet up here that I didn't mention before, and along the same lines, is many items that did not exist before, and so they had limited pricing data prior to the declaration of emergency. So, for example, COVID-19 testing kits, that's a new item. So figuring out what the proper price for that is, and what's the proper price that should be reimbursed by the government or by private payers, these are new questions. So as you know, it's a whole new world. Next slide, please. And Brad.
Thanks, John. Another issue that we want to highlight that is not a new issue, but could also have some new facets in this COVID-19 environment, and that's the waiver of patient responsibility, which is often referred to as the coinsurance, copays, and deductibles. These are important features of plans, as it's not going to be news to anybody on this call, because they serve many features. Often they serve the intent of driving folks in network and avoiding out-of-network utilization. They also give participants the opportunity to, and incentive to review their EOBs, which can be important in deterring fraud, because oftentimes it's a participant's tip that leads us to find out that services that were not rendered were in fact being billed to the plan. And when a provider, an out-of-network provider in particular, tries to remove those coinsurance, copays, and deductibles by offering to waive them and not charge the participant, it's a fraud upon the plan, because they are in fact misrepresenting the price that they are charging for their services. Instead of charging the full price, including that coinsurance, they're really charging a lesser price, and thus the plan's liability would be less as a result. So this has been shown to be fraudulent and has led to the conviction of healthcare providers, and it can lead to significant abuse in the plan. So it's something to watch out for, and we'll get to this later in the presentation when it comes to some administrative changes. But it'd be important that plans advise participants that they are responsible for the coinsurance and copays and deductibles in their healthcare services, and that the failure to pay those can result in the denial of the claim. Another type of fraud, and just to go back for a second, in the COVID-19 environment, of course, many testing and diagnostics are now mandated that there'd be no coinsurance or copays, and yet the treatment and services can be very expensive and will be subject to those. So providers may be particularly incentivized to waive those costs in order to lure participants into their shop where they can charge exorbitant amounts. Corporate fraud is a type of fraud where a non-doctor or layperson may take advantage or try to get around the corporate practice of medicine statutes that exist in most jurisdictions. These are statutes that protect the integrity of the healthcare industry and professions by mandating that medical providers be operated and owned by medical professionals. On the theory that you want a doctor or a other medical professional who has a professional interest in treating patients ethically and not excessively, as opposed to a corporate interest that will be, more beholden to its shareholders than it would be to patient care. And so, in this environment in particular, given the massive amounts of money that are flowing into the healthcare systems as a result of COVID-19, lay folks who want to get in on that money and are not doctors may try to do what they've done in other contexts, which is set up sham medical corporations that are not truly owned and operated by doctors in order to, funnel that money into their own pockets. And this can be fraudulent, has been found to be fraudulent, because when a bill comes in, it's signed by a doctor and it's represented that it's being done by a medical, a legitimate medical operation. And if that's not true, some courts have found that, every claim that comes out of that operation can be considered fraudulent. I'll pass it off to Rebecca, who's going to talk about collection and fraud litigation between providers and payers.
Thanks, Brad. So to kick off this discussion, first we'll talk about out-of-network providers bringing litigation against payers. So out-of-network providers who can attempt to bill payers any amount they please because they aren't contracted with the payers, if they're refused payment due to some suspected overcharging or improper fraudulent billing, this is often the starting point for a lawsuit brought by the provider against the plan. And we see lots of provider v. payer litigation and related to just basic pricing disputes, but most of the action is between out-of-network providers and payers because there are fewer rules. And in this COVID environment, we've noticed lately two slight changes to the complexion of these cases. One, massive multi-million-dollar bills per patient in a very short amount of time. And two, pleadings that really play on the emotions and lean on the pandemic and state of emergency as bolstering and justifying these enormous bills. And so only time will tell if the outcome in court will be effective using these types of bases to account for these larger bills. But since providers have suffered tremendous revenue losses during COVID, we expect overall that they've become very, very motivated to pursue reimbursement and collection swiftly through litigation. And providers pursue reimbursement in multiple ways. We see claims against plans under ERISA for benefits, breach of fiduciary duty, or other equitable relief, claims against insurers and ERISA plans or other payers under state law for claims based in contract, statute, or tort. For example, providers have brought claims for breach of contract where a mere phone call between them and somebody from their office and the plan administrator occurred and pricing or reimbursement rates were discussed. And they contend that through that phone call, a contract was formed. And then finally, depending on the unique facts, potentially there are other claims under RICO and False Claims Act.
Thanks, Rebecca. This slide here just touches on a few of the issues that often crop up in provider billing litigation, or litigation between providers and healthcare payers. And, all of these topics could lend themselves to presentations in their own, but I wanted to touch on a few at a high level here. First, the one of the first issues that confronts a defendant in receiving a provider billing suit is whether or not, especially if it's in state court, is whether or not to remove it to federal court. And that was often sort of the initial strategy in addressing any of these suits, whether it be by a provider or by a patient against a plan. We're seeing now courts be more and more reticent to entertain removal and are sending especially the provider suits back down to state court. So that's, it's a factor to be considered at the outset of litigation. And then ERISA preemption, which is, considered to be one of the most broad preemption statutes in all of federal law, is a very powerful defense against state law claims. For instance, the breach of contract claim that Rebecca just described, describing a contract between the plan and the payer, when really, the plan and the provider, when really, in reality, that breach of contract action is seeking plan benefits. And so the conflict preemption, as it's called, can be a very effective defense against provider claims. From a standing perspective, of course, every litigation, every plaintiff must have standing to bring suit, both constitutional and statutory standing. And ERISA statutory standing requires that it be one of the enumerated parties, a participant or beneficiary of the plan, a fiduciary or the Department of Labor. And providers, don't fit any of those three categories unless they've been assigned that claim and under a valid assignment. So those issues often come up. In addition, if the provider is bringing the claim on behalf of a participant, or if a participant's bringing a claim, and yet the provider never billed the participant, or as we talked about before, did not charge the participant for any of their liability, it raises the question of whether there's any actual constitutional standing, any actual concrete injury that participant has suffered, and it could be the basis for standing in court. And then pricing. John mentioned earlier that pricing of COVID-19 treatments and services are going to be, are brand new. So there's often going to be issues as to what a reasonable charge is. And plans often feature, in addition to in-network charge lists, limits on out-of-network charges based on a reasonable rate. And questions as to what is a reasonable rate will be prevalent in all provider litigations, or most provider litigations, and will certainly be prevalent in this COVID-19 environment. It's frequently the case when providers are responding to payers bringing up defenses like ERISA preemption or standing issues, that providers will plead that they don't have a remedy then if they can't sue the plan because they don't have standing, or because their state law claims are preempted. And the reality is the providers always have a remedy, and that's their remedy against patients, because patients frequently, when they go to a doctor's office before they get service, usually have to sign some assumption of liability form that says that they'll be responsible for any charges that their payer doesn't pay. How providers, for obvious reason, don't want to get into the business of suing their own patients, both because it's bad business and because patients are usually not deep pockets. But, we're seeing an increase in this type of litigation more and more. And it's something to look out for from a payer perspective, because it's not, it's also not good practice to have your participants being sued by providers. I'm going to turn it back over to Rebecca for actions and claims by payers against providers.
Yes. So when payers discover they have made payments which were the result of fraudulent claims or improper billing, they can initiate an action, which we often refer to as clawback actions, to recover payments they already made. And these claims for reimbursement may be presented as standalone lawsuits. They often are also brought as cross-claims or counterclaims in lawsuits providers have already initiated for non-payment or what they believe is underpayment for their submitted bills. Historically, we've seen clawback actions proceeding as ERISA claims for equitable relief at times, but due to recent Supreme Court authority in the Montanil case, which it has limited really a plan's ability to seek reimbursement under ERISA, which can be an hour-long presentation on its own, but we'll just flag that for now. Depending on the facts, payers can bring various actions under state law. As you see here, a few theories are listed, and states also have specific statutes directly addressing fraud, such as California's California Insurance Fraud Prevention Act cited here. And then finally, other potential federal claims can also be brought under RICO and the False Claims Act, which John will now dive into for you.
Thanks, Rebecca. Okay, RICO, the Racketeer Influenced and Corrupt Organizations Act, often referred to as RICO, is a federal law that provides for extensive criminal penalties and a civil cause of action for acts performed as part of an ongoing criminal organization. When you think RICO, we often think of the mob or the mafia or prosecutions, in the 1970s. However, RICO claims are not necessarily limited to allegations against organized crime. The elements of a civil RICO claim are, conduct of an enterprise through a pattern of racketeering activity. So what does this mean in practice? You can envision a scenario where a provider group is patient sharing or patient passing. Perhaps one provider gets hold of private health information, and that information is then passed around to other providers who bill for services not rendered or not performed. Again, there are these rings where that things like that could happen, or maybe there's a racket whereby providers self-refer to other providers in their social circle or that they work with, and again, sort of the idea of patient passing. But essentially, RICO provides a mechanism by which to go after ringleaders and organizers, of an organized plan or scheme or enterprise to drum up false billings. Related to RICO is this idea of conspiracy. Next slide, please. In the RICO statute, RICO has its own conspiracy provisions, but I wanted to flag briefly under state law, some jurisdictions have a separate cause of action for conspiracy to defraud. In some jurisdictions, conspiracy is merely more a theory of liability as opposed to a cause of action, meaning something along the lines of aiding and abetting or vicarious liability. But note that at least in some jurisdictions, you can have an independent conspiracy to defraud cause of action, and where it applies, that has sharp teeth as a remedy for private payers to bring a civil cause of action. I flagged here a couple of examples for you if you'd like to look at cases that involved RICO and civil conspiracy allegations. Next slide, please. All right. Separately is the False Claims Act. The False Claims Act, known as the FCA, is an American federal law that imposes liability on persons and companies who defraud government programs, such as Medicare. The False Claims Act is the federal government's primary litigation tool in combating fraud against the government. False Claims Act includes a qui tam provision that allows people who are not affiliated with the government, who we call relators, or qui tam plaintiffs, or whistleblowers, to file actions on behalf of the government. So they sue in the name of the government. The qui tam relator stands to receive a portion of any amount ultimately recovered. Just some stats on the False Claims Act and how it applies to healthcare and why we think it will be a driver in the COVID-19 era. As of 2019, over 71% of all FCA actions were initiated by whistleblowers. FCA claims often involve healthcare. The government recovered more than $62 billion into the FCA between 1987 and 2019, including more than $3 billion in 2019 alone. Next slide, please. The False Claims Act statute on its face identifies 7 types of prohibited conduct, often most litigated of which include the false claims provision, as well as the false statement provision. There's also a provision in there regarding overpayments. So even if money is innocently received in the first instance, once you discover that you were overpaid or that your entity wasn't entitled to that money, you must return it. The False Claims Act has sharp teeth. We've already talked about the whistleblower incentives, but the remedies include treble monetary recovery, which can be reduced in certain instances down to double recovery, as well as civil penalties per false claim, plus attorney's fees. The False Claims Act, it's a unique procedure. The procedure is unique. Essentially, what happens is a relator files suit under seal, meaning that the public doesn't have access to it. The government then has a period, initially 60 days, to investigate, although that is frequently extended. And then ultimately, the government has three choices, right? It can intervene and take control of the suit, at which point it can thereafter settle or prosecute it. Second, the government can decline to intervene and allow the relator to move forward and prosecute the action in the name of the state. Or three, in appropriate cases, the government may decide, no, this case has no merit, and the state may intervene and move to dismiss the lawsuit. False Claims Act raises all kinds of issues in defenses. I mean, what is the claim? What are the pleading standards? Materiality. I mentioned, I hinted earlier today at certification issues. Certainly, one scenario in play, right, is if you are a provider or a plan or any company that receives government stimulus dollars, you made certain express or implied certifications that you were eligible to receive those dollars, and there are strings attached. And if for whatever reason those certifications were false, you could face False Claims Act liability from the government. I guess I'd leave with, if a provider is submitting false claims to a private plan or insurer, query if they're also submitting false claims to the government. And the converse is also true, right? If an entity is, submitting false claims to the government, are they just as likely to be submitting false claims to the private plan or insurer? Brad?
Thanks, John. And I just want to stick here for a second because I think John's making a great point in terms of, one, trying to use the False Claims Act to go after fraudulent providers that are defrauding your plan. If your plan has Medicare-eligible participants and they're being seen by that provider, then the fraud upon your plan is also being perpetrated upon the government. And so the FCA can be a tool to go against and to deter fraudulent providers, even if the recovery is associated with fraud against the government. And two, the converse is true as well. I have counsel clients to review exclusion lists of state Medicare and Medicaid programs, as well as the federal OIG exclusion lists, because you can see providers that have been found to be defrauding those state and government programs, and check them against your own provider list because they may very well be perpetrating the exact same fraud upon your plan. And then next, we want to talk about state whistleblower laws. As John mentioned earlier, there are whistleblower laws protecting the federal government, and most states have similar laws enacted to protect against fraud of state government benefit programs. And most of them involve the state Medicaid funds, but there are also states that have whistleblower laws that protect all kinds of state benefit programs, including unemployment benefits and leave benefits. And most significantly, we want to highlight that a couple of states, California and Illinois, have passed statutes which are modeled after the FCA. They involve, as we'll get to, some of the same issues that the FCA presents, but instead of protecting the government programs against fraud, they are directly written to protect private payers against fraud, which is significant because when we talk about those laws, the state laws that exist that state plans and insurance companies can use to go after fraud, they're often dealing with negligence, or intentional torts like fraud and common law fraud, which can be very difficult to prove. You've got to prove, you've not only got to plead those with particularity, you've got to prove that there was reliance by the plan upon the fraudulent claim, et cetera. And the recovery is usually only what the plan paid out. However, like the False Claims Act, these state statutes, which again are designed to prevent fraud against private payers. If anybody is aware, any whistleblower or relator, as they're known in the statutes, is aware of fraud that's been committed against a private payer, be that an insurance company, and we'll get to issues involving self-insured plans, then that relator can bring suit that will result in, like the Federal Claims Act, False Claims Act, potentially large recoveries based on the treble assessments on the amount claimed, and that's amount claimed, not amount paid. So even if you didn't actually pay out a single dollar, as a result of those fraudulent claims, you can still bring suit and still get recovery, in addition to significant penalties per claim, regardless of whether that was paid. So we've seen some suits involving sort of low dollar high volume claims from providers like chiropractors or physical therapists or acupuncturists, which are sometimes committing fraud because they're not actually providing the services that they say they are. And we're talking about tens of thousands of claims that can come in from a single provider, and the penalties of $5,000 to $10,000 per claim can quickly add up. Another issue that we want to highlight here is, like the Federal False Claims Act, these require you to notify the government. So in the states of California and Illinois that have passed these, you've got to first inform usually the district attorney of the local jurisdiction or the Department of Insurance within that state. Let them know that this fraud is being perpetrated, and that government entity can step in and take over the suit, or they can intervene in order to increase the recovery for the state, or they can just let you go forward with it. There's a few issues. These statutes are new, so a lot of these things are still being tested out, but there are a few issues that have come up. One has been, what do you have to prove? And in a case in California that came up, the only thing that the plan had to prove was that the claim itself was, misleading, intentionally misleading. And which is a much easier standard than have to prove common law fraud, which of course, must include reliance. And two, as I referenced earlier, there's a question as to who can be a victim of this fraud under these statutes. They're written they're both in California and Illinois. They appear in the insurance code, and that's generally considered to only apply to insurance companies and not to self-insured plans. But insurance regulations are generally regulating those plans. They're not regulating fraud. And so in this instance, it's regulating fraud. And does a self-insured plan, for purposes of these statutes, constitute an insurance company? And we've been involved in at least one suit where the court found, yes, indeed, a self-insured plan, like an insurance company or an insured plan, is a contract of insurance. It's a contract to provide benefits, a contract with a participant to provide benefits for healthcare services. So indeed, these statutes can be a very effective tool in bringing suits against providers seeking, getting large recoveries, or even if you're not getting large recoveries because the providers often have squirreled away the money, you are creating a sentinel effect in the marketplace. You are deterring fraud from these providers and from future providers, and like I said, can get significant judgments.
Sure. Brad, real quick before you change gears to the next subject, two items. First, I just wanted to make one comment. Whether it's the state whistleblower statutes or also the False Claims Act, we've talked certainly about actions that can be against providers, but I did just want to flag that, plans and payers could find themselves as defendants in these actions as well. In fact, this morning, the federal government brought a False Claims Act against a payer entity. And these often involve, managed care organizations or capitated payments where plans are themselves receiving reimbursement from the government. Just that point, and then I wanted to provide the audience with the CLE code for today. That is Seyfarth Shaw, SS as in Seyfarth Shaw. So the code is SS2217. Once again, SS2217. Brad?
Great, thanks, John. Lastly, moving away from sort of the case law and the litigation and statutes, we want to talk about some administrative strategies and best practices that plans and payers can take to avoid litigation and to prevent fraud upon their participants and in their plan. First area is changes to plan terms. Earlier, we talked about the trend of out-of-network providers that are, that would seek to incentivize participants to come into their clinic as opposed to an in-network doctor by offering to waive the usually larger coinsurance or copays that the participant would be subject to. Again, while some courts have held that is fraudulent activity, in order for a plan to deny a claim on that, on the basis of that fee forgiveness, it's good practice to have in your plan document or in your SPD, the summary plan description, a notice to the participant that can actually form a basis of a claim denial. And we've put in the presentation some sample language that prohibits fee forgiveness, which would be a good idea to put in your SPD. Essentially putting them on notice, because courts have gone both ways on this. There's at least one court that has held no, unless you tell the participant that that's a basis for denial, you're not going to be able to use that as a reason to deny a claim. Allow recoupment, another feature that isn't always in an SPD or a plan document that would permit a plan to, and this can be a controversial practice, but it permit a plan to reduce future payments to a provider if they found that a previous claim was overpaid, by reason of mistake or fraud or any other reason. Put in your plan the ability for the plan to do that. Now, this practice is being challenged, and there was a very high-profile challenge when an insurance company was using this recoupment practice across different plans. In other words, to recover an overpayment made on behalf of one plan by reducing the payment for a different plan's payments to that same provider. But it's also being challenged, among plans doing it within their own patient population or even for the same patient. So it's at the very least, if you're going to engage in this practice, make sure that language is included in your plan language and probably the summary plan description. You'd be surprised how many plans I see don't actually have fraud as a basis to deny a claim. That's very rare for an administrator to deny a claim based on fraud, because you're not going through litigation or a full suit when you deny a claim. However, just having that language in your plan can be helpful in any future litigation, either with a provider that you may have counterclaims for fraud or in pursuing fraud claims against a provider. Also require participant cooperation. We talked about EOBs as being a very useful tool for participants to be able to flag fraud. But if you are trying to prove fraud against a provider, you're often going to need the cooperation of your participants and the patients who have seen that doctor. So having language in your plan that requires participants to respond to information requests about a provider and to otherwise cooperate with investigations is very important in pursuing fraud. Another strategy that some of our clients have used to protect their plans against fraud is actually to exclude a provider from future reimbursements. And you work with your administrators to find out about which providers are engaging in, whether it's fraudulent or just wasteful and abusive practices on a consistent basis and are not responding to, to any kind of training or otherwise. And you can take action if the trustees or the fiduciaries of your plan desire to exclude that provider from future reimbursements. But if you're going to do that, it's a good idea to have that codified in the plan document itself, and perhaps even in the SPD. And it'd be even a better idea to have the SPD reference any list of excluded providers so that participants are on notice, and it can't later be said that they didn't know that a doctor was excluded from the plan. And this can be a very effective, like I said before, reviewing sort of the OIG or state Medicare and Medicaid exclusion lists. Find those doctors that are committing fraud, see if they're in your plan, and exclude them from your plan too. Make sure that the contracts with your administrators are up to date and include protections for you as payers. Make sure that they acknowledge the obligations of the third-party administrator to administer the plan according to plan terms, to acknowledge their own fiduciary duties as, if they're making discretionary decisions, and to obligate them to make recoupments if your plan allows it. Those are good best practices to have within your plan language and in your contracts with your plan administrators. Another, it seems obvious, but when you're paying a claim, make sure that you have the opportunity to investigate the fraud beforehand. In today's environment with very large plans with thousands of participants, and with claims administration systems moving to more and more auto adjudications, oftentimes no human being touches a claim as the claim comes in and the money goes out the door. So it's important that there be systems in place that allow for, you can work with your administrator to put in place systems that will run those claims through a fraud prevention software or algorithm that will try to flag claims that are potentially fraudulent and pull them out for investigation. And make sure that you're doing that pre-payment, because if you don't and you're just trying to go backwards, you're going to have to pay and chase that money instead of preventing it from going out the door in the first place. And in the world of provider litigation and fraud litigation, it's often, if you're going to get that money back, it can be very difficult to do. So institute those claim edits. Put in a pre-authorization process that requires doctors and patients to get pre-authorization for certain types of claims, or all claims, but certain types of claims, especially that are subject to abuse, like for instance, physical medicine, like chiropractic services and physical therapy. It's a good idea to have a pre-authorization plan in place that would require those claims be pre-authorized before they're actually provided and then paid. We talked about kicking out abusive providers and known fraudsters. You can also institute those as a claim edit. So if you don't want to actually kick out the provider or exclude them from future reimbursement, at least flag their claims for more investigation. And that can be done at the administrative level before, again, payments are made. Lastly, and this is one I bring up in every presentation I give, because it's a practice that I strongly encourage that isn't often instituted in most plans, and that's putting in explanations of benefits for your for your pharmacy claims. Every claim has every plan has EOBs for the medical claims, but not every plan does it for pharmacy claims. Physical EOB that goes to the participant lets them know what has been paid on their behalf. And that can be critical, because we're seeing, especially with the high costs of prescription drugs and the rise of fraud involving things like compound drugs, millions and millions of dollars go out the door for a single patient or from a single provider or a single pharmacy that were never, ever received by that patient. And unless that patient got an EOB, they may never be aware of that. So the things that we've discussed earlier, like identity theft, where providers get a hold of patient health information and their member IDs, they can use that information to commit fraud upon your plan, and nobody will be the wiser, because the participant never got an EOB stating that they got a drug that they never received. So it's a good and easy administrative change that you can make to try to increase your fraud protections. And one that I don't have listed on here, but is common among plans, is in your SPD or publish it to your participants a hotline for fraud. Put it on your EOBs. Participants often don't know who to call if they suspect fraud, and the complaints of fraud can get lost because they're sent to the wrong individual or party. So if you put in a hotline that allows that participant to easily report fraud and get it to the right party, then you can have a jump on pursuing those leads.
Thanks, Brad. I think we're coming up toward, I'm sorry, did you? Yes, all right. Thanks, Brad. We're coming up to the end of the hour, so just give a couple of closing comments. First, I'll give you the CLE code one more time. It's SS, as in Seyfarth Shaw, SS2217. That's SS2217. So, we're running out of time. We'll review any questions that have been, presented to the panel, and we'll respond to those separately. We've spent the last hour, we've talked about issues and trends. Obviously, this was a high-level discussion. It was principally from the payer side perspective. Certainly, provider side, discussion is certainly another panel for another day. And then, these issues raise a host of additional considerations. We could do a separate panel altogether on mergers and acquisitions and consolidation in the healthcare industry, and sort of the breakdown of some of these traditional barriers between payers and providers. This webinar today was brought as part of the litigation, post-pandemic litigation series, and some of the fraud issues we've discussed, right, they may also permeate themselves in terms of consumer class actions, for price gouging and other areas, certainly employment litigation arising from COVID-19, and some, unfair competition, anti-competitive issues, some of the antitrust sort of concerns that we've sort of touched on, on the fringes today. But, we hope that this presentation has given you some things to consider. Up here on the slide is Seyfarth's COVID-19 resources. Certainly can learn more there, obviously Seyfarth.com. And thank you to the panel and to everyone who listened in during this hour.
Great, thanks everybody.
Thank you.